Bill Watch 39 2020 seconds in 2009 the now ruling ZANU-PF party formed a government of national unity with the MDC, and in the same year an act called the Zimbabwe National Security Council Act was promulgated with the aim of bringing the security services under civilian control. The act expired when the Government of National Unity ended in 2013, but the present constitution makes provision in Section 209 for a new National Security Council consisting of the President, who is chairperson, the Vice Presidents, and such other ministers, security service personnel and other persons as are determined in an Act of Parliament. The National Security Council has the following functions: to develop a national security policy, to inform and advise the President on national security matters, and to exercise other functions specified in an Act of Parliament. On the 6th June 2022, just short of 9 years after the Constitution came into operation, a bill was published in the Gazette to give effect to Section 209 of the Constitution. It is the National Security Council Bill, and it can be accessed on the Veritas website. It was presented in the National Assembly on the 18th July and is currently awaiting its second reading. According to the bill's memorandum, the purpose of the bill is to fill in the gaps left by the Constitution by specifying additional members and functions, and generally to bring the National Security Council into operation. The memorandum does not mention the main purpose of the original Zimbabwe National Security Council Act, namely to bring the security services under civilian control. We shall return to this point later. The main provisions of the bill are the following. Under Clause 3 of the bill, the Council will consist of the following members in addition to the President and Vice President, who are members by virtue of Section 209 of the Constitution: the ministers responsible for national intelligence, defense, the police, prisons and finance, the Chief Secretary to the President and Cabinet, the Commander of the Defense Forces and of the Army and Air Force, the Commissioners General of Police, of Prisons and Correctional Service, and of the Intelligence Services, and any additional ministers the President may appoint to the Council in consultation with any of the ministers referred to above. Clause 4 of the bill purports to set out how the Council is to exercise its functions, but in fact it gives the Council two new ones: to keep the state in a state of preparedness to meet any threat to its security, and to exercise any other function which the Council or the Cabinet considers to be necessary in the interests of national security. Clause 5 of the bill states that the Council must meet at times and places determined by the President, and that it must meet at least once every 3 months. And its committees will not be open to the public, but the Council will be able to inform the public of its resolutions if it is necessary to do so in the public interest. Clause 6 of the bill will require heads of each security service to submit reports to the Council in such form as may be prescribed on security-related matters relating to their services. Clause 7 of the bill will give the Council powers to issue general or specific directives to any security service or person in connection with matters of national security. Security services and persons to whom directives are given will have to comply with them, though they will be entitled to receive all the state support necessary to enable them to comply. Will have to contain safeguards to protect the fundamental rights of individuals, but not, apparently, companies, which also have fundamental rights. In Clause 8 of the bill, members and former members of the Council are enjoined not to disclose any information obtained by virtue of their membership. The clause also prohibits anyone from disclosing security-related information if they have an obligation under any other law not to disclose it. The last clause of the bill, Clause 9, states that the President may report on the state of security when giving his annual State of the Nation address in terms of Section 144 of the Constitution. We have already noted some omissions in the bill regarding the Council's meetings. There are others. The bill gives Parliament no role whatever in the nation's security or the Council's affairs. Even though our constitution does not contain a provision equivalent to section 198d of the South African Constitution, which states that national security is subject to the authority of Parliament, our constitution does say in section 119 that Parliament has power to ensure that all institutions and agencies of government at every level act constitutionally and in the national interest, and for that purpose, this provision applies to all governmental institutions, including the Council, and the bill should have some mechanism by which Parliament can check up on how the Council is exercising its functions. It may be undesirable for sensitive security information to be disclosed publicly in Parliament, but a special committee of Parliament could be set up to consider security issues and receive sensitive information in closed hearings. If the Council is to hold meetings, someone has to convene them, distribute papers, see that venues are suitably equipped and so on. The bill does not indicate who is to do this: staff of the President's office, military personnel, police officers, prison warders, or who. Keeping the Council running will entail some government expenditure, though one hopes not very much. The bill should indicate which ministry or department must pay for it and where the money is to come from, because section 303(1) of the Constitution states, without suitable provision in the bill, the expenses of the Council cannot be met from the Consolidated Revenue Fund. The bill is a critical bill as it provides for issues of national security and the peace and stability of the country. The bill also a necessary one because it gives effect to the Constitution. Which raises two questions: why has it taken so long, nearly 9 years, to bring the bill before Parliament? And what has been done about national security during those 9 years? The Council cannot have been operating because in the absence of legislation its only members have been those specified in section 209 of the Constitution, namely the President and his Vice Presidents. We mentioned at the beginning of this bulletin that the purpose of the 2009 Zimbabwe National Security Council Act was to bring the security services under civilian control. The bill does go some way towards this by involving the President, Vice Presidents and Ministers, most of whom are civilians, in making decisions regarding national security. The bill does not go far enough, however, because it skirts over the question of how decisions will be reached at council meetings. Will the military and security officers be able to outvote the civilians, or will the President and his ministers have the final say? Secondly, it gives Parliament no role in formulating national security policies or in overseeing how the policies are carried out. It is to be hoped that the bill will be passed by Parliament without undue delay and that the defects and omissions we have noted are rectified during its passage. V.